Hello, everyone, and thanks for joining. This is another WISE-ACT webinar, and great to see also some people who haven't seen for a while. So thanks for joining, and apologies for any technical challenges that we always have. So thanks to Federico Costantini, who was our working group 1 leader, co-leader, and leader, and for agreeing to make this webinar today. So it's a quite interesting and really contemporary topic, actually. So Federico is based at the University of Udine. He has different hats, different roles, but he comes from the legal background, legal expertise. And he's looking at different types of technologies. But more recently, he also focused a bit on the different platforms. And this is a topic that cuts across different areas of WISE-ACT, but of different initiatives. And I can see how also Suzanne, Sonopolis have been very active in this area, and other organizations across Europe and beyond. So just to finish off, I'll say that Federico was also the data protection officer at the University of Udine for a while, so he has lots of expertise in this field. And on that note, Federico, I'll pass the mic to you and let you go on for about 20 minutes or so, and we'll leave a couple of minutes for some follow-up discussion.
Thank you very much. And yes, I've been a data protection officer of my university, and as I always say, I'm still a free man. So this is good news for me, but also for the University of Udine. Today, I would like to talk about data protection, which is, of course, an horizontal issue in digital platforms. And I will focus on the concerns that emerged in Italy concerning the data protection of the riders. And I discovered recently of the drivers of all these platforms that are spreading across the world. So as you can see from my presentation, I would, at the beginning, present some news which are not coming from Italy. And then I will try to draw the context, which is the context of platform workers and digital platforms. And then I will dig into the Italian cases which were addressed against Deliveroo, Foodora, let's say Foodino, and Uber. And I will provide some observations concerning a microscopic perspective, which regard issues concerning data protection related to employees, clients, and customers. And then I will try to enlarge the perspective into a microscopic one, presenting a new model, a new strategy, which is based on the concept of cybersecurity as a common good. At the end, I will offer some conclusions, and I will wait for your questions. So, latest news are not from Italy, but from Netherlands, sorry. And the fact is that Uber was sued and lost a case against the data protection officer of this country concerning the robot firing algorithm which was used for the drivers, and for having denied access to data, to alleging the presence of trade secrets. And there was another side cause concerning Ola, which tried to profile the drivers according to a fraud probability score. This is interesting because the cases I will present, the meaning is not that the Italian supervisor is, let's say, more rigorous than the others in the Europe, but the concern concerning data protection is a widespread issue. So what are we talking about? Here I will provide a short definition of online platforms as seen in this publication. Let's say that basically that they are organizations that create a peer-to-peer structure between or among many operators. And this is very interesting from the business model perspective. They try to generate and take advantage of the network effects So the synergy among all these businesses and customers and users creates new intelligence and new ecosystems. Let's say that a digital platform has the target of creating an ecosystem which is detached from others. There are many digital platforms. In this publication, we can see that they detect 4 kinds of platforms. In our case, the idea is that we focus on digital labor platforms. We need to specify that there are different kinds of digital labor platforms. The ones that create a physical service task and they match the market needs with the offerings of the providers. And this is what we are talking here. And then there are others kind of digital platforms which are not focused in this talk. So what is the deal with the Italian data protection supervisor? Here you can see a list of the fines that were addressed to all these digital platforms operator. And you can see that the total amount of these fines is more or less about 10 million euros, which is not, let's say, it is very conspicuous as an amount of euros to be paid for data protection infringements. The fact is that these platforms, and here I start focusing on the first one because it is very interesting, and the others will be described more or less in, let's say, by differentiating what is the functionalities of the others too. They basically are based on an onboarding of the driver, which in the case of Fudinho entails the personal colloquium. And this is very interesting. Each rider pays 65 euros for the backpack that they are using and carrying on the streets. This is the only one case in which the rider is compelled to pay for the equipment. They download the application on the mobile device. In case of the Fudinho, it's called Glover. And at this point, they are more or less ready to work. The definition of time slot is key and is crucial in each of these platforms. In the case of Fudinho, is 1 hour. And here start all the algorithm which assigns the order and places the price. For example, in the case of Fudinho, 5 cents for each minute of waiting and a bonus for any weather and other variables. Then there is the placement of the order and the order acceptance and the confirmation of the withdrawal of the delivery. At the end, they are paid every 15 days. From the technical perspective, there is this kind of algorithm that scores the how the rider works, and you can see that there are different percentages depending on several factors. They assign priorities to specific drivers, and then they calculate the reliability, the rejection coefficient, the reassignment coefficient, the seniority. And this is very interesting. All these data that are collected during this work are assessed from a dashboard. This dashboard, in the case of Fudinho, allowed some profiles to assess the data of all the riders in all the countries in which Glovo were active. The general manager and the head of operation has this kind of God view perspective. And they were able also to assess details of the riders. And this is very interesting and fascinating, but scaring at the same time. There is a kind of live map functionality where you can see all the riders crawling in the map and riding in real time. And you can see the active riders, and the map updates with the update positioning of the riders. The geolocalization in the case of Fudinho updated every 15 seconds. Other platforms, the update was 12 seconds. So it is very detailed, and the data handling, it is based, and this is surprising, on a Google Drive, on an Excel stored on a Google Drive. And from this kind of storage, the duration, the time under which these data are stored is 4 years, was 4 years. So in this all crawling and writing and processing of data, which were the infringements that the Italian supervisor found? There was a lack of transparency concerning the data, how the data were processed, how the review were elaborated by the algorithm. There was no data protection officer. You have thousands of people riding in the streets, and you don't name, you don't determine one figure that is supervising the data protection. This is basically incredible. Only after a while, they started to take into consideration this kind of compliance. The term of storage was too long, and it was undiscriminated. 4 years for each kind of data, it is too much. No minimization, the fact that each rider in each country could be seen and monitored, it is something that is unbelievable. No data protection impact assessment. This is a very, very huge mistake made by Fudinho, but it was not the only one. The data protection impact assessment is the crucial thing to do when you have so many people running and so huge collection of data. This is the basic of data protection. They didn't do that because in these cases of geolocalization, live monitoring, automatic assignment, automatic scoring, you need to do that. And these were about 20,000 riders, and they didn't do that. So for me, this is embarrassing, at least. Insufficient security measures. This was another, let's say, reason to be fined. And this is very interesting. They missed cooperation with the authorities. So the fact that when asked, they didn't provide enough information and comply with the requests of the Italian authority. And they were, of course, fined also for that. Deliveroo is working in the same way. The data controller is in UK, is in UK. In this case, we have less riders, 8,000, but the geolocalization and the way they handle the data is much more or less the same. In this case, they stored the email for 6 years. So each rider communicated with the customer center through email, and they stored all this data for 6 years, which is a lot. Deliveroo was fined for lack of transparency because they didn't provide enough information to the workers, and they record also the telephone calls for 28 days, and this is also unbelievable. They were all monitored and surveilled. No minimization of data processing, lack of security also in this case. Afterwards, they segregated the data country by country, but at the beginning, they didn't do that. And there was this algorithm, which was called Frank, for handling personal profiling and ranking and so on. And just as Fudinho, they didn't do any data protection impact assessment. And then the fact that they did not make an inventory of all the processing activities, which was not updated or provided to the authority, which is another big mistake in data compliance. And of course, they didn't took into consideration the fact that in Italy we have a special legislation concerning the remote control of workers, and they didn't comply with that. So this is the reason for the fine in this case. Concerning Uber, it was the situation was a bit different. Uber was in a bit of a problem because they were put under judicial administration because, according to the law, they did not comply with the rules concerning the employment, and based on that, they had to handle the administration, the management of this company to a commissioner nominated by the Court of Milan, and they started comply with the laws. And at the end, for 1 year, they managed to be compliant at the end of this period. The reason why Uber was fined by the authority was that they were a victim of a data breach in 2016. The data breach concerned the withdrawal of data of a lot of people, 300,000 customers and 50,000 drivers. And this data breach was not notified in a right way. So at the end, they also objected the Italian jurisdiction, which instead was stated. So yeah, and they did not comply with the new rule of GDPR, which states that two companies can also manage and handle data together. And so the Italian authority decided that they were joint controllers and they had to comply with such regulation. Or again, also here, lack of transparency, and interestingly, the decision stated that there was a kind of intensity of criminal intent because they were very negligent in the handling of the data and of the data breach. So they were fined. The fines were very high also for this reason. But these are the cases that were decided by the Italian supervisor. But now I want to provide you another example, which is more recent and more, let's say, near to my personal experience. And this is the information notice coming from an application which you can download on the device. And this application can be used by companies for car sharing services. So the employees of a company, they download all these applications and they start to share the cars to coming at work. This is the translation, of course, of the information notice of this company. And as you can see, the company states that the data will be communicated, collected, the tax code, which is not useful, so this is a violation of data minimization, to the relevant community, which is something that is not defined. What is the community and why my colleague should know my tax code or other details that are not necessary for the car sharing. And here it is the most interesting part. The company providing this service states that with the consent of the data subject, they can do something with his or her data. For example, make suggestions and recommendations, which is another way to say you are profiled under your consent. This is interesting. This could be done. The problem is that the application used for this car service does not have any button concerning the consent. So this is illegal because what is stated in the notice is not what you can really interact with this platform. And this is a very huge mistake made not towards the let's say data subject, but this is a sign, in my opinion, that the business model is not correct, that is not conducted in respecting the value of the data. So here are my considerations, and I'm going to the end of these slides. Data protection is important For employees' rights, of course, this is the field of the labor law. For customer rights, of course, customer protection, European legislation, and so on. But also for business purposes, the data-driven management can be done only if you treat correctly the data. And this is very important to say that data protection is not just fundamental rights and privacy. Data protection is a way to create value through data. And this is another perspective, the macroscopic perspective, the fact that cybersecurity has become a common good. Because in the European Union political strategy, something has changed in these years. And you can see from all these the provisions that the cybersecurity has become crucial, not only because of criminal attacks or enemy states and the war and so on, but because it is important to defend the infrastructures. This is the Cyber Solidarity Act, which has been proposed in these days. So there is a change of paradigm on cybersecurity. The past paradigm was that companies are against customers because they want to profile us, and we don't want to be profiled. The companies are against employees because they want to control them, to surveil, to make surveillance of them. Governments are against companies because they want to control the market and so on. This has changed, of course, censorship, because cybersecurity has become a shared interest. So a common good. This is a new perspective that has to be taken into consideration. So conclusion. The conclusions are the importance of accountability. You have to be accountable and show that you are interested in treating correctly the data. Data protection is not a bureaucratic task, but a useful tool. The complexity of labor market has to be taken into consideration. You have different levels of salary, different labor conditions, different union collective agreements. You have to take care of that. You cannot jump into a market and pretend to be treated as the king. The value of personal data has a problem, which is the data transfer. Now we are seeing that the European Union and the USA are starting to agree under new terms of condition concerning data transfer. But if you are familiar with the web legislation, you see that the use of Google Analytics by companies and institutions has become a real issue. And this is the last recent opinion concerning this problem. Cybersecurity, again, is a common good. You are not alone in information security, but you have to comply at least with data protection. Here I stand. This is an image that I took in Salzburg the last time I went there to a conference, and you see that it's kind of a base of riders, which is a kind of respecting these people and allowing them to wait for the orders, not under the rain, but in a fair and safe condition. At the end, I will leave the references, but then I shut up and I leave the floor again to Nicolas, and I thank him for having me here. Thank you very much.
Thank you, Federico. That's great, actually. You did touch upon very many interesting issues. So I think we're going to have a useful and fruitful discussion